Welcome to Jurisedge Academy's YouTube channel. In this video, we are going to discuss important weekly legal news from 17 January to 22nd January 2022. In first important news, the Supreme Court has held that Section 5 of the Limitation Act does not apply to civil suits in civil courts. In the case of Sunil Kumar Mehti versus State Bank of India, the court has noted that Section 5 of the Limitation Act does not apply to civil suits instituted in civil courts. In second important news, the Supreme Court has reiterated the concept of reservation is not against the idea of merits. In the case of Neil Aurelio Nunes versus Union of India, the court has said that merit should be socially contextualized and reconceptualized because reservation is not at odds with merits, but simply furthers the distributive consequences of social justice. The court has said that merit cannot be reduced to narrow definitions of performance in an open competitive examination, which only provides formal equality of opportunity. Open competitive examinations do not reflect the social, economic, and cultural advantage that accrues to certain classes and contributes to their success in such examinations. High scores in an examination are not a proxy for merit. In third important news, the Supreme Court has held that inherited property of a female Hindu dying issueless and intestate reverts back to the source. In the case of Arunachala Gondar versus Ponnuswamy, the court has held that inherited property of a Hindu female dying issueless and intestate reverts back to the source. If a female Hindu dies intestate without leaving any issue, then the property inherited by her from her father or mother would go to the heirs of her father, whereas the property inherited from her husband or father-in-law would go to the heirs of the husband. In fourth important news, the Supreme Court has held that high courts cannot direct the states to form a new policy. In the case of Krishan Lal versus Vinny Mahajan, the court has held that it is a well-settled position that the High Court cannot issue directions to the state to form a new policy, and the matter ought to be analyzed on its own merits in accordance with law. Lastly, the Supreme Court has held that subordinate legislation is also law under Section 23 of the Indian Contract Act. In the case of G.T. Girish versus Y. Subbaraju, the court has held that subordinate legislation or statutory rules are also law under Section 23 of the Indian Contract Act. It is important to note that Section 23 of the Contract Act states that the consideration or object of an agreement is lawful unless it is forbidden by law. Therefore, the court has held that what is contemplated under Section 23 of the Indian Contract Act is law in all its forms, being immunized from encroachment and infringement by a contract being enforced. Not only would a statutory rule be law within the meaning of Article 13 of the Constitution of India, but it would also be law under Section 23 of the Indian Contract Act. This brings us to the end of our weekly legal update. If you like this video, please like and share and subscribe to our YouTube channel.